concept of psychosocial risk is far from new, but the dialogue and industry discussion about the topic has elevated since regulatory changes were announced in 2023 and 2024. Psychosocial risk is now the focus of many conversations in the corporate world, from boardrooms to executive teams, and of course through to the practitioners on the ground, trying to join the dots to have meaningful impact. I'm Kate Connors. I'm a master's qualified psychologist, and my professional purpose is to help people and workplaces be at their best.
And I'm Greg Smith. I'm a lawyer who's spent more than 30 years practicing in the areas of employment law and workplace health and safety. I'm also the author of several books, including Paper Safe and the recently published Proving Safety.
And you are listening to Judgmental, when a psychologist and a lawyer walk into a barside chat about psychosocial risk. A big thanks to our sponsor, EML. EML are Australia's largest personal injury claims provider, providing claims management services to workers' compensation, life insurance and CTP markets, with the purpose of helping people get their lives back. We have another jam-packed episode today, so grab a drink and sit back for another discussion at the bar. Hello, listeners, and thank you for walking into the virtual bar with Greg and I again today for this very special episode of Judgmental. Before we kick off, I would like to acknowledge the traditional custodians of the lands that I'm on today, being the lands of the Wurundjeri people of the Kulin Nation. And Greg, I'm sure you would like to do the same. Welcome, Greg Smith.
Good afternoon, Kate. I think it's afternoon where you are, morning where I am, and I'm coming to you from the lands of the Whadjuk people of the Noongar Nation, and I also pay my respects to the Whadjuk people of the Noongar Nation and their elders, past, present and emerging. Good to see you again.
We are. Yes, I know. Here we are again.
Happy New Year. We're back on deck in the bar, talking things
in the bar. Do you have a general principle by when you stop saying Happy New Year? What do you tend to go by?
Oh, I'd be finished by about now, end of January, early Feb. But the problem is then you bump into people in April that you haven't seen since before Christmas. But April is too far. April is too far.
I agree. Well, as
what
I said,
about?
Yes, let's get back to the point.
Yeah.
We are doing our very first special episode, and in the discussions and in the thinking about where we wanted to take the podcast, we thought it would be really sensible to have what we will call special editions if there is something particularly relevant and a little bit more of a time kind of sensitive point, or for our conversation to stay relevant from a time and context perspective. And with that in mind, was last week or the week before the High Court decision came through from a case that we discussed in our first series. So we thought that it would make sense to do a special episode on that, and which is really going to mean that you're leading the show today, Greg. Is that fair?
Okay. It's okay. I think it makes sense. I mean, we try to plan out what we want to talk about by series, but as you know, every now and again something pops up and it's worth a discussion. And this is one of them. So yeah, we talked about the Vision Australia case. That was one of our earliest episodes, I think. And that involved a series of cases involving a fellow called Mr Elisha against his employer, Vision Australia, where he sued his employer for breach of contract for psychosocial harm arising from the termination of his employment, where it was generally accepted that his employment was terminated in breach of his employment contract because the employer didn't properly follow the policies and procedures they'd prescribed. And Mr Elijah was awarded $1.4 million. So that case went through the Victorian Supreme Court, and then Victorian Supreme Court on appeal, ended up in the High Court. And in very broad terms, the High Court accepted the initial decision that said Mr Elijah was entitled to damages, and said that the entitlement to damages was still $1.4 million. So at the end of the day, we have an employee who sued his employer for breach of contract resulting in psychosocial harm and got a $1.4 million damages claim. Now, fundamentally, from So at its most basic, I guess, the argument was whether a person could get damages for psychosocial harm caused by the termination of their employment at its core. And the defence, or Vision Australia, was relying on a 1909 English King's Bench decision called Adidas and Gramophone. And so ultimately the court came up really with two things and one interesting side thing. But the two things were, first of all, the court said that the Adidas decision, perhaps I'll go back a step. There's been lots of commentary that the High Court has somehow introduced some sort of new principle of law and overturned the Adidas decision. The court didn't do that. All the court said was the Adidas decision didn't decide that damages can never be recovered for psychiatric injury that arise out of the termination of employment in the context of breach of contract. So the case had accepted that Vision Australia's policies and procedures relating to disciplinary action and termination of employment, or significant parts of them, had been incorporated into the contract of employment. Those policies and procedures were not complied with because allegations were not properly put to Mr Elisha. He wasn't given a proper opportunity to respond. And some of the factors that were used to decide whether Mr Elisha should be terminated were not the factors that were put to him. And you talked about a lot how that can cause psychiatric or stress and lead to injury for workers involved in that process. So that was all agreed. Those procedures were accepted. Vision Australia had argued that as a principle of law, you can't recover damages arising from the termination of your employment. The High Court said, no, that's wrong, you can. And so we had a case of breach of contract leading to psychiatric illness and injury, therefore entitled to compensation. There was a secondary argument that is, again, there's nothing new about the secondary argument, the question of whether the damages arising from the breach of contract were too, and the legal term is too remote.
Too remote, I saw all of that, yeah.
Yeah, so could it be considered that that kind of psychiatric injury or psychiatric injury could have been in the contemplation of the parties when they wrote the contract? The High Court said in this case the answer to that question was yes, and that will always be a question of fact on a case-by-case basis. So no new legal principles there, nothing particularly surprising. There is a third issue that has nothing to do with psychiatric injury or damages at all. It's got to do with a deed of release, but I might talk about that later. But, Kate, we talked about this quite a bit when the appeal decision at least first came out. What were your observations looking at the High Court?
Well, my first observation, which I mentioned to you before we began recording, was, certainly as a psychologist, never ever read a High Court decision on a Friday and expect for it to make any sense to you, because I can't saw tail of it. And that's what I messaged you. I said, I don't think I can. And you just said, High Court decision. I thought, okay. So that helps me to not feel quite as much of a dum-dum. So that was the first thing. But I actually was a little bit more impressed with myself this morning. On Monday morning and feeling a bit more cognitively fresh, I was able to make a little bit more sense of it. So that was one point that I just thought was of relevance to the non-legal people listening when we do put our heads into these decisions to try to make sense of them, that they can be hard to understand.
They can be.
Sometimes quite hard to comprehend what it is that is actually being said. But with that said, there were a few things that I noticed on reading this decision, which I found just interesting again, Greg, which I think whether they're a point of relevance legally, I think in our broader mission to try to improve safety literacy and psychological literacy, that maybe in these things that I noticed, there might be some interesting takeouts for people. And the first of that was in regards to when the decision got to the point of damages. In paragraph 49, there's this really interesting quote, and it said, anxiety is an almost inevitable concomitant of expectations based on promises. A contracting party must be deemed to be at risk of it. So I don't know, I just thought that was really interesting principle that the court was saying, Yeah, you're putting yourself at risk whenever you enter into any kind of contract with someone, and anxiety about my expectations or what I think is about to unfold here. You're placing yourself at risk in any kind of engagement like that. And I think that when I read that, I thought that was really relevant in the context of, and you talk about this a lot and I talk about this a lot in terms of what employers promise, be it brand promise, be it in process and policy promise, that those things matter, that those promises do matter. And again, that just takes me back, I guess, that I think it's really interesting the way judges write these decisions and some of the wisdoms that come from them.
Can I ask a question on that, Kate?
Yeah.
Do you have any sense at the moment that employers in this sort of reaction to psychosocial risk are over-promising?
I think that it's a real risk that because there's now more case law saying tick and flick exercises, which I think that might be something that we will explore in series 2, that recent decision that came out about a tick and flick risk assessment, that it really does matter what you say versus what you do. And your whole premise around this with paper safe, improving safety, has been something you've been talking about a lot with your legal hat on. But I think that's where you and I are so aligned, and the way that I talk about that is when I use the phrasing when employers get so anchored in how it looks versus how it is. I mean, and in a way, I think I've used this phrase before, that sense of gaslighting, almost this sense of gaslighting to people that can happen at an institutional level if you're going around making these big, bold brand promises and not delivering on them. So, and with that in mind, in terms of do I think that employers are overpromising, I actually had a question to you. Where do you think that the line sits in terms of if an employer was to say, well, we don't do that, and therefore try to manage the risk of not following the processes?
I think it's...
If that makes sense. Did that make any sense?
And I think there's a bit of this going on, organisations trying to say let's not draw attention to it because we'll be held liable for it. At its most basic, across most jurisdictions, the standard you're held accountable to is as a reasonable employer.
Yeah.
And in this day and age, and particularly given there are now psychosocial codes of practice around, I think there's a minimum standard of behaviour that organisations will be held accountable to. So I don't think you can pretend like it doesn't exist and think that'll somehow manage your legal risk, because obviously it won't. So yeah, I don't think avoidance strategies work, but I don't think over-promising takes us anywhere as well. The one that I'm most concerned about, that I see bump around a little bit, and I haven't seen any direct, I've seen some legal fallout, not psychosocial harm, but I imagine that'll be there, is when you get employers who promise to complainants in particular that this is not going to go any further, or we will protect you from having to say anything further, and something that you simply can't, a promise that you can't keep. It's not within your control to keep, and how that might play out in some circumstances.
Which links back in with that case we discussed last series around HR practitioners promising confidentiality.
There's something.
Yeah. Well, I do think that there's also this connection into that, which was in, again, a really lovely quote from paragraph 66 of the decision, which I really wanted to, again, draw to attention, this idea of injury versus illness and hurt versus harm. And in the judgment, it says, injury to feelings is a common day experience and is something distinct from illness.
Yeah.
And I think that that is such an important concept, that I think it is one that unless employers, seek advice, are reasonable, do get the right tone of what is it that because in this idea that I've talked about before about adulting, right? Like, people can have their feelings hurt, or you can feel uncomfortable and it doesn't feel nice, but that's different to being harmed, i.e. sustaining an illness or an injury. Yeah. So I think that's going to be one that continues to roll around. And I think that is a really, really important concept for people to consider. It's not crisp, right? And I think people gloss over that too much and therefore get too processy, right, we've got to do this grievance thing or we've got to follow that or we've got to follow the other, fearing that they will be seen to have not acted formally when actually maybe that's just dialing up unnecessarily and causing more process issues down the track.
I know we're going to cover this in some later episodes, but consistent with that, we're seeing an increased number of bullying allegations that are being found not to be bullying.
Yeah.
Where people are bringing claims and the courts and tribunals are saying an unpleasant demeanour is not bullying, an aggressive tone is not bullying. The line is really quite interesting. And the risk, of course, is if we overreact to every concern that gets raised in the workplace, there's a potential that we'll actually create harm where none exists, potentially.
Absolutely. And I would bring that into a psychological language by saying it creates hypervigilance. Like everyone's nervous system and threat response system is in overdrive because you become so singularly concerned that something is going to be misunderstood, misheard, that someone's going to say something about you that when that was never your intent. And I think that that's particularly relevant for people in leadership and management roles as they try to manage performance, as they try to lean into challenging team dynamics or conflict issues, and then avoidance happens, right? And so then it's down this path of an unintended consequence of mismanaging or being totally absent as a leader because they're trying to avoid being in the receipt of, well, you said this and you were bullying me or you were harassing me. Yeah, it's just, it can end up being quite difficult for people to navigate unless they feel the organisational system that they're operating within is being reasonable and is being sensible about how things are responded to.
Yes, I agree with that. And I think consistent with that, part of the rationale behind this conversation for me is I do think we need a more sophisticated and nuanced discussion about some of this case law. Because if you, the way the Elijah decision has been sort of put out there in the public domain, it really is, if you don't follow your termination procedures, you're up for a $1.4 million liability. But you do need to go back and actually read the conduct that gave rise to the psychosocial harm. It wasn't a one-off harsh conversation. It was an almost calculated process. I think it was described in one of the decisions as a sham process to kind of get this person's employment terminated regardless of the merits of what was going on.
Yeah. I think that's a really good segue into this other reflection that I had in terms of the language in the decision. Greg, paragraph 69, there was reference to the unfathomable nature of what occurred was the language in the decision. And I think with that, I think that was really close in the decision to when there was reference to the expert witness in regards to the psychological response that the worker had, and that evidence was that the worker's perception was extraordinary. And yet the judge actually determined that no, that wasn't the case. Like, considering the unfathomable nature of what this person experienced, that it absolutely was fathomable and was reasonable to see that degree of psychological harm. So I think that for me, on reading that did speak to the importance of the meaning making that people do when they're on the receiving end of what is clearly not fair. So it's just not fair. You know, you're sacking me for stuff that you didn't even tell me about and that we've never discussed. And ultimately that was what was found in this case.
Yep. I think that's the right observation.
Yeah.
And in part, it's disingenuous is probably putting it a bit too highly, but if you're not going to comply with your own procedures, by and large, you are kind of accountable for the consequences of those procedures. Now, I'm sure there are going to be cases in the future where a level of reaction to a level of conduct will be found to be so out of kilter that this is just not a reasonable response. I suspect that's the case. Like, we already see that. So we see that in cases that don't involve psychosocial harm in the employment context. So people will fire off emails and make all these responses and resign their employment and say, I was left with no choice but to resign because of the behaviour I was subjected to. And the courts or the commissions are perfectly willing to say that response to what occurred is completely out of all perspective to actually what occurred. It'll be interesting to see how this develops, and it's not my area of expertise, so I just drop it in as a place marker. This idea whether if an employer is engaged in conduct that could lead to psychosocial harm, once you cross that threshold and say, yes, it's foreseeable that that behaviour could cause psychosocial harm to a person, whether you are then responsible for all the consequences of that psychosocial harm, even if the response of the individual may be more than what you would ordinarily expect. And the thing I think about is, and again, not professing any expertise here, but I think I'm right in saying a few decades ago, we looked at this issue of the sort of eggshell skull. So this idea that you hit somebody or push somebody and they fall and hit their head and die because they had, some sort of weakness in their skull. That's not a defense. It's not a defense to say if that person didn't have that condition, they wouldn't have died. Therefore, I'm not accountable. It's, well, no, you're accountable for your conduct sort of thing.
Yeah.
It'll be interesting to see how the jurisprudence actually develops around these sorts of things going forward.
Which is maybe another good segue into this, which I'm understanding must be a legal term in terms of coherence, because what you just said then is very coherent with workers' compensation, and like you take the whole person, right?
Yeah.
Like that tends to be the way that in all of the frameworks I've ever worked in and provided advice in, you take a human as you find them, and any of the actions that you then take, there is a connection back into a duty of care.
The principal coherence issue in this...
Tell me about this coherence thing.
It hasn't been decided. There's a New South Wales decision, I can't recall the name of it, it's in the judgment, that is based on. But the principal coherence decision is in the Fair Work Commission for unfair dismissal proceedings, hurt, humiliation, distress, effectively psychosocial harm, is expressly excluded from damages. So you have a maximum damage for an unfair dismissal of 6 months remuneration or reinstatement. Okay. And there is no capacity for the Fair Work Commission to award damages based on any hurt, humiliation or distress.
Because otherwise it would be incongruent or incoherent with that earlier frame. Is that what that means? Right.
No, that's just what the legislation says.
Okay.
And so what Vision Australia in part argued in the Elijah decision was that if you award damages arising from the termination of employment, that is incoherent with existing legislation that says you're not entitled to those damages. That's what the argument was.
Right.
And the court found, the High Court, as I read the decision, found they didn't really need to address that issue because this is damages for breach of contract as opposed to damages for termination of employment.
Termination, gotcha, okay. Because when I was reading that, things that you'd said before came to my mind around the different legal frameworks and how sometimes they're all saying different things. And I thought, how does that apply? Is there any sense of internal coherence, or is this your key argument that there isn't a good sense of coherence across the legal jurisdictions or legal frameworks, but they need to be coherent internal? So internal coherence within, say, Fair Work, but not necessarily then as it then applies to workplace health and safety.
Yeah, yes. I think that's right. So, but that's, you don't necessarily have to have, again, it's, I probably need to do more work on this. You don't necessarily have to have coherence between work health and safety legislation and employment legislation.
Yeah.
Yeah. But when you're creating new legal rights through the common law by the application of judgments, you need to be coherent with the existing law and the statutory frameworks. So
which if I distill that is why when you say it's so complicated for employers, it's so complicated for employers. Yeah, that's the kind of legal reason for that, is because there doesn't need to be coherence across the different frameworks.
Yes, So,
yeah.
So you're sitting in the middle of a psychosocial complaint in the workplace, and you've got this intersection of employment law, workers' comp law, contract law, potentially work health and safety legislation, and those things. Yeah, so there's a fair bit there. And again, one of the interesting things about this case, which sort of hasn't been talked about publicly too much, is that Mr Elijah initially brought an unfair dismissal case in the Fair Work Commission. That was settled. He got paid a reasonable chunk of money for that. He signed a deed of release, and then he brought the new proceedings.
These separate proceeding, yeah.
And the court accepted or found that the deed of release for the unfair dismissal was not sufficient to bar the later proceedings. Now, if the deed of settlement and release had have been sufficient, then the case wouldn't have gone any further. It simply wouldn't have progressed. So the deed related to the employment and the termination of the employment, but it didn't bar the court found it didn't bar any other actions. So, for example, it didn't specifically prohibit further proceedings for breach of contract.
And when I saw your note when you were thinking through and we were in prep for this conversation, that would be a key takeout, that people, from a legal sense, I'll be honest with you, that then I have a bit of an allergic reaction to that.
Yeah, I'm sure you did.
Like, okay, so yeah, maybe let's not overcook the chicken. But I think that does create, well, I don't know. What does that then mean in terms of it's gone all the way to the High Court? This has been the determination of the High Court that damages were appropriate and were awarded. All of the points of appeal were reflected upon and were discounted, and the decision has held.
Yep.
And I think for me, as someone who has spent my professional career supporting people who have experienced psychological harm or trying to advise organisations on how to try to minimise harm to their people, that if a key takeout was, let's just make sure that we draft our deeds of release differently so we don't have to pay compensation for it, but it doesn't change our practices, that's terrible.
Well, stepping back from that a little bit, there's a couple of things you could do to avoid risk in this case. One would be to properly draft your employment policies and contracts of employment.
Yep.
So that those provisions don't get incorporated into your contracts. And if those policies and procedures weren't incorporated into the contract, there may not have been a cause of action at all.
Can I stop you there, Greg? Isn't any kind of policy or process, isn't that your whole paper safe kind of piece? That anything that's written down as a policy or process of an organisation deemed to have some kind of legal standing if an employee doesn't follow it?
It certainly does in the context of health and safety prosecutions, right. But it's a different conversation, again, to say whether a policy then becomes incorporated into your employment contract. They're two very different conversations. And the other thing, of course, to understand is that in a deed of settlement and release, you cannot exclude workers' compensation.
Yes.
So regardless of what that deed may have said, at the end of the day, Mr Elijah, even after his employment was terminated, always had the option of going into the workers' compensation regime. And I don't know if he did. I can't remember looking at the decision. That's what I mean. There's all these different streams that spin off these sorts of cases. But, certainly from an employer's perspective, there's probably three key takeaways for me. One is, just as a matter of good practice, follow your own guidance material when it comes to disciplinary action and termination, and try and be reasonable about those processes. But from technical legal perspectives, draft your policies in your employment contract so that those kind of processes are not incorporated into contract. And if you are going to terminate someone's employment, pay attention to that process. And if you're going to settle it, make sure your settlements are good enough to cover you for future proceedings.
You can see me with a little wry little look on my face as the psychologist sitting here.
None of those things preclude taking care for the welfare of your people.
Yeah. And I think that, I don't know, do we agree that is our overarching connection for everything that really you and I do talk about, isn't it? Is that really there is no replacing taking good care of your people in a genuinely meaningful and effective way is a broad brushed effective way of managing the risk and managing the legal risk as well.
Yes, if you are prepared to accept. I'm going to back in the lawyers.
Here we go. This is the caveat.
Well, it's not a caveat, but I think we have to accept, even with the best will and care in the world, from time to time, performance management issues spin out of our control.
Totally. And that's humans.
And that's when you need your legal protections in place, as much as anything.
And I think that is, if we bring this discussion to a close, because just conscious that this is a special episode, that's just a little wrap up of this particular case. But ultimately, that's what's so hard about this, is that you can do with your heart in the right place, fully genuine intent to try to do the right thing, human to human in these kinds of situations. And sometimes it still doesn't go as you'd hoped. And that is why this work is so hard and so complex, and why it's important to get the right advice and to think about it carefully.
I think so. Okay.
Yeah.
So our first special episode, Kate. Thank you for letting me indulge myself on a high court decision. I appreciate it.
Thank you for being very kind when I messaged you and I was trying to read that decision going, oh my God, I can't make head nor tail of this. And you just say, Kate, it's okay. It's a high court decision. They're harder to read.
I thought it was a very well-written decision. But anyway.
Well, that draws this episode to a close, and we will be back to regular programming with Series 2. So thanks for joining us, and we hope you keep listening, and look forward to you joining us next time in the bar.
Thanks, Kate. Thanks, everyone.
That's a wrap for another episode of Judgmental. Thanks again to our sponsors, EML. EML's Mutual Benefits Program provides organisations with free services, tools and resources to manage their workplace risk. You can follow EML, myself and Greg on LinkedIn, and be sure to check the show notes for links to the papers referenced in each episode, as well as resources available to help you as you navigate the wonderfully complex and nuanced world of psychosocial risk. See you again next time at the bar.